Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about bubble zones and the constitutional protection of freedom of expression. Bubble zones, also known as safe access laws, prohibit protests within defined geographic areas. Anyone who protests within the protected bubble can face penalties, sometimes criminal in nature. Originally developed to prevent pro life protests around abortion clinics after some high profile incidents of serious violence, the use of bubble zones has rapidly expanded. There are now bubble zones around hospitals, healthcare facilities, schools, libraries, community centers, arts centers, and recently a Liberal MP proposed creating bubble zones around MP offices. While bubble zones have been upheld in courts, but in the context of abortion clinics, these other new expansions have not been tested. Would they survive constitutional scrutiny? Are these policies necessary to protect vulnerable people, or are they censoring discussion and silencing debate? Here today to discuss the issue are two experts, Professor Richard Moon of the University of Windsor School of Law and Ga Grant from the BC Civil Liberties Association. Thank you both so much for joining me today. Professor Moon, let's start with the origins of these bubble zone laws, which I understand began in the 1990s in Canada, with the first one being in BC. What can you tell me about the context that led up to the enactment of the laws, including some of that violence that we saw in the early 90s?
Yeah, I think predating the BC law was in fact an injunction that was issued in Ontario in relation to one of the clinics or the clinics established by Henry Morgentaler, principally in Toronto. Um, a- and as you said in the introduction, I think the principal concern behind these laws and initially the injunction was safety and security of those involved, those either working or attending as patients, the clinics. I think there's also been an expansion or extension of our understanding of the necessity for these zones, and that relates to a sense of a privacy or dignity of those attending these, and that's something maybe we can talk about in a minute. What are the rights or interests of individuals in public spaces not to be confronted with speech that they might consider to be invasive, harsh in some way?
Now, Gav, I know that the British Columbia Civil Liberties Association, when the first bubble law was introduced, and some people call it a statutory injunction because I guess it operates the way that pre-bubble zone injunction law it makes it sort of a statutized injunction. When that first was introduced as a statute, the BC Civil Liberties Association opposed it. Um, the BC law was challenged in a case called R and Lewis, and it was upheld. But I understand the BC Civil Liberties Association has changed their position now. So, what's your take on the abortion clinic bubble zones now and on the RV Lewis case?
Yes, so while the BCCLA did initially oppose abortion bubble zones, that decision was reversed not long after by our board. Although we've had concerns about how bubble zones are being used and the transparency about when new bubble zones are being declared and how they're doing that. So the contention is really around the justification for the bubble zones, although there's no doubt that in our view that and in the court's view that these were restrictions on freedom of expression, and in our view they also impact assembly, potentially liberty and mobility interests as well. That's where the debate has mostly been at whether this can really rise to the justification of the Oakes test, and we haven't changed our view that abortion bubble zones in the specific context of someone's right to access reproductive healthcare and that protected Section 7 right with safety and dignity and privacy, as in the Lewis decision, still remains.
So the Oakes test, for those who are watching and maybe not familiar with some of the language that lawyers use, is a test used under Section 1 of the Charter. So once a right, like the right to freedom of expression, is engaged or it's being violated, what the court does is it asks if under Section 1 of the Charter that limit can be demonstrably justified in a free and democratic society. And the answer to that question is answered through an analytical framework from a case called Oakes that asks a number of questions, including whether the impairment is, whether it's minimally impairing, whether it's proportionate, and what the public purpose being served is. We've got to go to commercial break right now, but we will be right back.